Doubts. I'm just not understanding feasibility.
So again, I think what's in the record is that with respect to these books as they were deployed in the classroom, there was high absenteeism in some schools. For example, dozens of students being opted out in, I think Mr. Baxter said the average size of an elementary school in Montgomery County is 700 students. So each grade is 125. If you have dozens of students walking out, making arrangements for those students to have adequate space and supervision and alternative instruction, I think is infeasible.
But then they do it for all sorts of other opt-outs.
They don't do it for all sorts of other opt-outs. There's a limited universe of things that students can opt out from. The Family Life and Healthy Sexuality curriculum stands alone. It is mandated by the state. It is something where you are able to predict precisely when the curriculum is going to be deployed. There's a It's
the most similar substantively to what we have here, and there's an opt-out allowed there. I guess I'm not understanding why Montgomery County School Board stands alone. I think in the country, you can tell me if there's another school board that's done something like this.
I apologize.
Both the kind of books that are being used and prohibiting opt-outs. And I guess I'm just not understanding the whole goal, I think, of some of our religion precedents is to look for the win-win, to look for the situation where you can respect the religious beliefs and accommodate the religious beliefs while the state or city or whatever it may be can pursue its goals. And here they're not asking you to change what's taught in the classroom. They're not asking you to change that at all. A lot of the rhetoric suggests that they might have, that they were trying to do that, but that's not what they're trying to do. They're only seeking to be able to walk out so that they don't have to, the parents don't have their children exposed to these things that are contrary to their own beliefs.
I understand, Your Honor, and there may well be circumstances where a school can, or a school district can engineer the win-win. Montgomery County schools try to accomplish an educational goal of introducing these books for a particular purpose. They then attempted to accommodate religious opt-outs in the school, and they weren't able.
Mr. Schoenfeld, what is that purpose? I mean, I thought the answer to Justice Kavanaugh's question was that the school board was explicit that the books were to be used only to supplement the English language arts curriculum as reading instruction and not to teach about gender or sexuality. So it wasn't as though the books were being introduced for the purpose of enhancing the gender and sexuality component, and therefore people can opt out of that whole thing. It was the
students were opting out.
Was that because they found the materials objectionable or for religious reasons or what?
There are two different paragraphs of her declaration that speak to this fact. In that paragraph, it doesn't specify. Elsewhere in the declaration, it makes clear that many of
some of the plaintiffs are devout Muslims. They say we have a solemn religious obligation to raise our children as Muslims, and that involves certain moral principles that we want to instill in our children, and the school is teaching our children moral principles that are in conflict with ours, and we pay taxes to support the public schools, but we don't have enough money to send our children to private schools, and one of us can't stay home and provide homeschooling, so we just want to be able to take our children out of the part of the instruction that we find objectionable. And what's your response to that? Your response to that is just, well, it's too bad, all right? This is the public school, and the public school can teach what the public school wants, and you don't like that? Well, you can send your children to private schools.
There's no indifference to the religious beliefs of the petitioners in this case. The school did what it could to accommodate those views. There are simply circumstances in which what the petitioner or what any plaintiff recognizes that a burden on their religious belief is not a legally cognizable one, given legal and practical justice.
Well, it's nice that you say that they respect
elected. The entire process of adopting this curriculum is open and transparent. These books are on review for 30 days before they're even made part of the curriculum. There's then a multi-level appeal process. There's plenty of opportunity for parental insight. And just to draw an analogy to another case from this court, in Bowen versus Roy, there was no dispute that the assignment of a Social Security number would rob little bird of the snow of her spirit. And this court made the judgment in that case that fully crediting the sincerity of that belief and fully crediting what the parents described as the imposition on their daughter, there was still some breathing room that the government needed to be given to operate in that case.
And you think that providing an opt-out under these circumstances where you already allow opt-outs from the health class and opt-outs for other things is comparable to what the plaintiff